an appeal in the matter of Cole and Hawkins and others.
Good morning, it's Mr. Lee.
It is. Good morning, my lady. Good morning, your lordships. I appear with Mr. Williams. You'll know he was trial counsel. We're instructed by a firm of solicitors. My learned friend, Mr. Brannigan, appears. He's instructed directly from Mr. Carl, the respondent to the appeal, the claimant in the trial below, using counsel who has the conduct of litigation approved credentials. So it's perhaps less common practice. So my learned friend appears directly, but he's, well, I thought he appeared directly, but thinking about it, if he's been instructed by someone who has the conduct of litigation approved certification, that makes him akin to a solicitor, I presume, but maybe that doesn't matter for these purposes. But there we are. Mr. Brannigan, Mr. Williams and myself will be the advocates in this case. By way of housekeeping, the list shows an application by the other side at the start of the hearing to deal with some documentation which they wanted to put in, which has been described as an unagreed bundle. I've indicated to my learned friend that my position is neutral on it, and having looked at it, indeed, there's a couple of documents I would refer to, but he needs the permission of the court to put in some extra documents that aren't in the bundle heretofore, and I'm hoping, notwithstanding the look from the court, that the court's had a copy of this unagreed bundle.
We have this. We wouldn't ordinarily in this situation take a lot of time up with this sort of application anyway. We might look at the documents de bene esse, but if you're saying you're not objecting to it, I think we just proceed.
Precisely. Well, as I said, I'm neutral. Therefore, in terms of housekeeping, the court should have a core bundle,
yes,
which was updated on the 11th of June. So the updated core bundle runs to 17 tabs, ending at page 352.
Yes. I'm not sure we've got the hard copy additional tabs, but we were certainly sent, I assume it's 2 skeletons at the end.
The additional documentation were, yes, exactly right, my lady, 16 and 17 were respondents' supplemental skeleton, 25 May, and this year, and the appellant's skeleton argument in reply dated 10th of June 26. That's effectively the substantial skeleton. So that's the core bundle updated. There is a supplementary core bundle as well. That has 8 tabs up to page 103. Subject to what the learned friend wants to do, I don't anticipating taking your ladyship and lordships through much of the documentation, but for completeness. There is a bundle of authorities, and there's obviously then the now admitted additional bundle, and then there's a bundle of authorities which originally had 12 tabs in, and then this morning, and I believe a copy was sent to at least one of your clerks, tab 13, a case of Warden Donnellan, which in fact your ladyship I think was the judge last Friday.
Well, I was one of the constitution.
Yes, and my learned friends put it in this morning out of an abundance of fairness. Yes. In due course he may well argue it assists him. Certainly I would be arguing to the contrary, but I want to make sure your ladyship and lordships have the case of Ward and Donnellan, which was only handed down last Friday.
Well, I have it electronically.
The learned friend's got copies, I believe.
Okay.
I brought some copies.
Right, thank you. They can be handed up at the appropriate
Shall we do that now for completeness to save shuffling at the point?
I have hole punched unstapled, and I have stapled, depending on the preference of the board.
Stapled for me, please.
It found its way to me, and my clerk has hole punched it, so I will spare you one of your holes.
Right.
3 copies. I think my lord indicated he had a hole punched one and might want a stapled one as well. He did want a stapled one as well. Thank you very much.
my lady, my lords, what I propose doing, particularly so far as any legal submissions are concerned, particularly involving the most recent case, I've made them already in my skeleton. It might be easier if I respond as required once my learned friends made any either fresh points in the law that he makes. What I proposed doing was some opening remarks just to set the scene a little more than what I've done in our rather brief additional skeleton, and then deal with the argument as necessary, plus of course any matters arising from the bench, if that commends itself to the court. So, housekeeping out the way, but by way of introduction, and I appreciate, of course, the court's had a chance to read the bundles. As the court knows, this was a case brought by Mr. Carl in a somewhat scattergun approach against a number of people who he thought had wronged him in relation to purchasing or attempting to purchase motor cars. So far as Mr. Limbani is concerned, which is the only person we're concerned with in terms of the defendants today, I want to make the following points, and I can draw your attention to some of the documentation. Mr. Limbani, as you will know from the defence, which didn't find much description in the judgment, but in the defence, in the main bundle at page 272, that's 272 in the main bundle, you will see there in the first two paragraphs how Mr. Limbani found himself brought into the litigation. He was a driver, chauffeur. He was employed by several of the defendants to run them around. And on the basis that he had been the driver, he was considered by Mr. Carl to be someone appropriate to sue. To set in context this some 7-day trial, Mr. Limbani was not there throughout the entire trial. He had been very seriously ill and was recovering. Therefore, counsel, Mr. Williams, was there for him, and his instructing solicitors who sit behind me today. And a point came when Mr. Limbani gave evidence which, following a CPR report being put in as to his health, he was permitted to give evidence remotely. So he gave evidence for about an hour, remotely. And that consisted of the entire time that the judge, trial judge, actually saw Mr. Limbani and heard him. And in our submission, that is a highly relevant matter when I come to make submissions on making a judicial decision on costs that might sound in behaviour.
I hesitate to rise, but, and I wasn't going to rise, but my learned friend is just now giving evidence from the bench as to what went on in the trial.
Yes, I know.
And I'm in an impossible position to deal with that standing here today. And given that this is the opening point and is now characterised as perhaps the central point being put forward, it's regrettable.
Well, we'll hear the argument. You can make your points about how relevant it is in any event.
Thank you, my lady. And of course, although my learned friend stands on behalf of Mr. Carl today, Mr. Carl himself is listening to what's being said. And
yes,
can give instructions, notwithstanding the distance. Nowadays one can give instructions remotely.
Indeed.
And it's a matter of record. I put it this way because it colours, it doesn't take away from the submissions that I've already made. I can still make them. But it does seem to me that this court should know the context in which a trial judge, after 7 days, completely dismissing all of the claims against the party, then makes no costs.
Cutting to the chase, Mr. Lee, you've got to deal with the findings that the judge did make, ultimately you will have to deal with the findings that the judge did make in his substantive judgment.
I'll come to that if I may, but I need to set my stall up first of all. The second point, and it now arises from the documentation that the learned friend has put in. The court may be less familiar given the fact that this is perhaps the last substantive piece of material. But just before turning to that, can I invite the court to again look at the main bundle? And if the court turns to, I believe, it's page 205, it's 205 or 204 down the bottom, it's internal page 10 of the approved judgment, and it's paragraph 23. Paragraph 23 of the judgment. Somewhere in the middle of that page, the judge had been dealing with what Mr. Limbani, in his view, might have known. About 2/3 of the way down, the sentence beginning, Mr. Carl's objective was not to obtain damages from Mr. Limbani, but to persuade him to give evidence as to what he knew of the dealings involving his cars, an effort which Mr. Limbani stoutly resisted, etc. We know the judge's views. But that's rather crucial because the judge himself characterised the assault on Mr. Limbani as a tactical one by Mr. Carl to obtain evidence to use against others. And to reinforce that, to demonstrate why that is quite so, if the court takes up this new bundle and turns to the internally numbered page 54. We're just going to look at a few emails. Appreciate the court's not seen these before. If I can jump on the relevant paragraphs, but of course if the court or my learned friend wants me to say more, I'll do so. Starting on page 54 is an email back in March of 24. This concerns Mr. Carl effectively making an offer that if Mr. Limbani would give evidence against co-defendants, Mr. Carl would take him out of the litigation and pay some, as it turned out, some £5,000 towards his cost. Of course, at that stage, Mr. Limbani's costs with solicitors were far, far greater than that. So the problem was he'd been embroiled in litigation. But nonetheless, this is the point. Down the bottom there, dealing with this offer from Mr. Carl. This is, however, a condition to this offer, conditional on your client providing full and frank evidence at trial concerning his involvement with Richard Edwards and Trevor Smith regarding my stolen cars, and particularly with regard to the movement of those cars and storage payments made by Lorna Edwards to A. Limban after those cars were removed from the dealership at Malton at her husband or Trevor Smith's direction. Obviously, what would constitute full and frank evidence is subjective, so I would suggest that if your client were interested in the proposal, you provide me with a proffer of what his testimony would be on a totally confidential basis. I could not use at trial in the absence of a settlement. Turning to the next page, the next month, please consider this an update to my prior Part 36 and settlement offers. I'm prepared to settle all my claims, including costs, against Limbani in return for a refund of the $5,000 in costs I just paid to RPF and my instructing solicitors, Mr. Limbani's solicitors, and a commitment by Limbaby, obviously misspelt, to testify, if needed, at the upcoming trial in this case and or at a future trial in the possible private prosecution of Richard Edwards and certain of his associates. You know, of course, that there was at some point a trial against Mr. Edwards. If I can just move forward to page 58, two more pages to look at. 58, an email from Mr. Carr, 7th of May, again returning to this offer. He now says, you can see there, he refers to risking another 60,000 in fees. This was reflecting some figure around, it was probably more, that was owed to my instructing solicitors. So what he says, I waive any agreement on cooperating on my private prosecution. And then the last document, page 59, 8th of May, my solicitors write back to Mr. Carl. You no longer need our client's assistance in pursuing your present claim against the active defendants, Mr. Howarth and Mrs. Edwards, D4 and D5. We also note you don't require our client's assistance in your proposed private prosecution against Mr. Edwards. In the circumstances, we request you file a notice of discontinuance forthwith. And as the court will no doubt apprehend, there was no notice of discontinuance. That, of course, in the ordinary way, unless there was an agreement, which there wasn't, would have meant that the notice would have meant that Mr. Carl was liable for our costs. So I introduced that material to the court that's in the papers because it certainly underlines and very much colours how it was we then get to a trial, we get a judgment in which Mr. Limbani features very little, in which anything the judge says about Mr. Limbani makes no difference or no material difference because the judge doesn't identify anything concerning either the conduct of the trial or the bringing of the litigation. As the court will appreciate, I won't rehearse my skeleton. The court's had a chance to read it. But the court sees in our skeleton the fundamental point that costs, as wide a discretion as a trial judge has, are not to be considered whimsically. For example, reductio ad absurdum, it's not for the court to say, I'm not going to give you your costs, Mr. Lee, even though you've won the trial, because I didn't like the suits you wore to court every day. That would be absurd, but equally, it might be something the judge personally felt. Now, in this particular case, notwithstanding, and unless the court requires me, we don't need to trawl through the judgment. There is absolutely nothing in that whole judgment, and it's a long judgment, where the judge says something adverse about Mr. Limbani, who he clearly doesn't like or didn't like, that has a bearing on any of the familiar matters that relate to costs. There's nothing that lengthened the litigation, there's nothing that lengthened the trial, there's nothing that took everybody down a dead end. There's not even, given what we've just looked at, something which says Mr. Limbani brought this claim upon himself. Because the judge recognised in his judgment, and the emails demonstrate, that what Mr. Carr was doing was bringing a claim, effectively in terrorem. He was bringing a claim to threaten Mr. Limbani. If you don't cooperate with me, you will be on the other side of the litigation defending. Some might consider that an abusive process. Be that as it may, this matter had to go through to trial to work out what happened. And it's quite clear in the very limited passages in this long judgment that deal with Mr. Limbani's defence and effectively Mr. Carr's claim, Mr. Carr lost hands down. One may say with hindsight, that's not surprising. When you're suing people for conversion, for basically stealing your property or money that was to be used to acquire items for you, and you sue the driver of that person, one may question the extent to which the driver really had any involvement. But that was the way Mr. Carl conducted his own litigation. That was the way he brought the claim. It's for that reason that, whereas my learned friend in his skeleton accuses us, at paragraph 2 of his skeleton, of mischaracterising under ground 1 the basis, with respect, as one says, my learned friend misunderstands what it is we're complaining about. The judge never made an adverse finding against Mr. Limbani that has anything to do with costs in a non-whimsical sense.
I just want to understand the argument. We've got the findings that the judge makes, and you've made your submission
Yes.
that those are not findings of matters that have a cost consequence.
Exactly.
But are you bringing any challenge to the findings themselves? Because
No.
there are hints of that in the earlier skeleton references to hearsay and matters of that nature.
Well, my lord, there was evidence that I'm told which should have been excluded at trial concerning, for example, the police officer's witness evidence. Rulings were made by prior judges, but at trial the judge said, I'm going to let it all in. So everything went in. So the police officer who gives an account hearsay of a conversation with my client, which eventually the judge decides I prefer the police officer's hearsay recollection rather than yours, because the police officer never gave evidence. It would not be proportionate or appropriate, having won the trial, to attempt to reverse findings of a judge that didn't go to costs and didn't go to an issue in the case. So had the judge actually made a costs award that we would not want to disturb, we would not have made any appeal to say, I know we won, the other side lost, I know we got some or all of our costs, but you said some unkind things about us. It wouldn't matter.
Well, there's jurisdiction in this court that you can't bring appeals of that kind.
Precisely, my lord. So it would be wholly wrong. So Mr. Williams, in my submission, because obviously he sought and got permission to appeal, I'm somewhat Johnny-come-lately. The appeal is on the more important, or the important point. Did the judge make a decision in the sense of formulating, in a transparent manner that we can scrutinise, a decision on costs of the substantive trial, not the other consequential matters which were dealt with, because there was a lot of cost order before the trial. And that's what all the evidence my learned friend puts in about skeletons and cost bundles and so on. They were an entirely separate matter. Again, without rehearsing my skeleton, the court will know what happened was, in the judgment, the judge said very clearly, I'm making a provisional view as to costs. Page 192 of the bundle, page 192. This is the paragraph 427 of the judgment. In terms, I'm prepared to hear further submissions on the award, on both the award and the quantum of costs before making a final determination, since the parties should have the opportunity to clarify their positions. Absolutely right. Matter of fairness, and clearly one doesn't need to look at authorities to see that you make a decision based on representations from everybody affected by that decision. However, my preliminary views are as set out below, and we know what he thought. Fine, he can have a preliminary view, but that doesn't matter. It's a preliminary view. But then, and you have his judgment now, 194 is an extract from the consequential judgment.
Sorry, 194 is the original.
Yeah, sorry, I meant
That's
the original.
The
My
paragraph
apologies.
dealing with Mr.
Yeah,
Mr.
433.
Limbani.
Yes, my lady. 433 of the original judgment, 494. But it doesn't detract from what he's already said, but for completeness. There'll be no order for costs in respect of Limbani. Reason is he escaped examination of conduct through a policy of evasion, non-disclosure. I have insufficient evidence before me to determine whether or not he was a part of the conspiracy, but I'm entirely clear that he knew of and disregarded court orders in respect of cars. He was not provided with the disclosure which he was ordered to provide. I note in this regard Mr. Cole put to Limbani in the witness box, he'd given no disclosure. I paraphrase it, in the witness box, as you now know, it was a remote cross-examination, and Limbani testified there was absolutely nothing to disclose by way of communications. I think that's clearly untrue. I've no problem in principle with the deny everything defence, but once it's become clear that the party seeking to avoid examination of their actions through a strategy of deliberate non-disclosure, I think that the party, even if successful in deflecting liability, should not have their costs incurred. Now, with the utmost respect to the trial judge, that is not a proper judicial consideration of costs. The starting point is, as we all know, the loser pays. In all the authorities, beyond peradventure, the loser pays the costs. We know in this case that Mr. Carl brought these proceedings tactically to coerce Mr. Limbani to help him. Now, it's one thing for the judge to decide that he's had a deny everything defence. He's perfectly entitled to. Claimant brings a case. Claimant has to prove the case on balanced probabilities. Either the defendant will put things in that might help him or says nothing. He can take his chances.
But I mean, do you not think if one had read Mr. Limbani's defence and then discovered in the course of his evidence that his wife was being paid £500 a month by reference to invoices called storage,
yes,
the judge might well be troubled by whether everything Mr. Limbani was in a position to assist the court with, he had in fact chosen to share.
My lord, that would be a valid point, but for this. A whiff of illegality, a whiff of some wrongfulness, in and of itself is not enough, both for the purposes of determining trial issues and most certainly not enough for the purposes of determining a costs matter, for these reasons. If the judge had thought that whatever his adverse considerations about Mr. Limbani were that he recorded in his judgment, if they went to a trial issue, he was perfectly entitled, as judges do up and down the country, to make a ruling to the effect that he accepts one version of the case, the claimant's version in this case it would have been, notwithstanding what's said by the defendant, because he not only doesn't believe them, he actually thinks what they're not telling him is the truth of what actually happened. That is far removed from the situation we have. He thinks Mr. Limbani's wife was involved in something about which Mr. Limbani wasn't truthful. But it had not a jot's worth of bearing on the outcome of the case. It was open to the judge to take his plain dislike of Mr. Limbani, his adverse findings against Mr. Limbani, and use them to justify a finding in favour of Mr. Carl. If he'd done that, then... I'm sorry, my lady, if I could just finish. If he'd have done that, I wouldn't be able to stand here and say none of this is relevant to the determination. But that is our fundamental point. Whatever the judge says, it didn't affect the outcome. Therefore, it's no different from my example of someone wearing the wrong colour suit to court. If it doesn't go to a cost matter, it doesn't matter if the judge finds Mr. Limbani unhelpful, dishonest, his wife who involved, as it were, on the side. It doesn't matter.
Okay, can I clarify? I think you're saying, I just want to understand this, that those comments where the judge made adverse findings about Mr. Limbani, I don't think you've quite saying this, but it amounts to saying they weren't relevant to the issues in the case. Or
yes.
You're putting it slightly different way, perhaps deliberately, which is they didn't affect the outcome.
It does amount to the same result. In a trial, and forgive me, this is trite, but in a trial, one makes determinations of relevant issues. Those relevant issues then inform the decision as to which way the judge's decision goes. As part of that decision-making process, the judge has to, as the fact finder, make findings of fact. If it's documents, that's relatively easy, subject, of course, to them being frauds, but he can make a finding of a fraudulent documentation. When it comes to witnesses, of course, the judge sees a witness in front of themselves and decides whether the witness was truthful or not. But again, as the cost cases show us, in and of itself, exaggeration or even dishonesty, in and of itself, isn't a reason to take away from someone the right to defend themselves and recover their costs. When one makes a cost decision, it has to have a bearing on costs, or in some way the court has to say the party whose costs I'm not going to award in their favour has behaved so egregiously, so dishonestly. But even then, I'm bound to say, if one's making a cost decision, the determining factors have to be things that go to cost. Length of trial, bringing the trial upon yourself in the first place, time spent at the trial that wasn't needed, even if you did win the point, etc. And so, my lady, you do, as it were, characterise what we say, because this is the thrust of our case. It doesn't matter what the judge kept saying in his judgment, and that's why we don't have to appeal it. It did not go to a trial matter. That's the important point.
Yes, I'm afraid that didn't jump out of the skeleton arguments as being your key argument. But I think I understand it. Well, I think we understand it. We have your point.
Yes, obviously perhaps I pulled my language. One sometimes gets a bit enthusiastic drafting these things, and then one culls. It was certainly, may I just read what I said? Well, paragraph 7 is one aspect, but that comes later.
Sorry, are you talking about your later skeleton?
Yes, sorry, my later, the skeleton from a learned offender myself. I thought I just clarify that what I said. Yes, paragraph 11. The judgment doesn't identify conduct of the appellant which brought the proceedings against him, lengthened the trial, or inhibited the respondent's, Mr. Carl's, ability to pursue claims fully. On the judge's own finding, the appellant was not held liable on any claim and was not found to have caused wasted costs.
Yeah. Okay, I don't think that quite puts it as you're putting it now.
Well,
I mean, we thought your primary argument was going to be about procedural fairness, but that's not the way you're arguing it now.
Procedural fairness is certainly a part of my argument, because I have to deal with the grounds that have been given approval. But parasitic upon making a decision in a judicial manner, as it were, relevant, taken into account, irrelevant, considered, reasonably minded, decision maker, and obviously not perverse. The judge having indicated, that is part of my case, I don't resolve from that, but I'm starting on the first point, that the judge did not make a decision on cost at all, and nothing in his findings would have allowed him to do so. So that's my primary position, that we don't have a cost, we have a cost decision because the judge said no order for costs. But what we don't have is a properly exercised judicial function as to why he should not have awarded my client's costs, given the rather specific findings that he made. He was bound to have, had he applied his mind to it. Unfortunately, shut Mr. Williams down, and whatever said, Mr. Williams, there's a limit to how far one can push a judge who's made it clear that they're not interested in hearing from you. In fact, the judge said rather presciently, well, take it to the Court of Appeal, and here we are. Some might say that's unfortunate, but nonetheless, here we are. What I would, if I can then turn from the primary point to develop this point, but you have it already because I've shown you the paragraphs. This judge said, I'm making a provisional finding, of course I'll hear submissions on it, but I wouldn't expect a judge to say otherwise. Unfortunately, the misstep that occurs is in our skeleton, actually, we for ease, I've extracted in skeleton, page 5 of our, internally of our skeleton, we've captured the passage from the relevant transcript just for ease. So I pause there. Our case is, contrary to what the other side says, and the documentation speaks for itself, and unless the court wants me to trawl through it, it's plain as a pikestaff that what Mr. Williams dealt with was all the was not the substantive costs, but all the other cost matters. It's quite clear.
I think one question, at least I have, is what happens. I think it's early on in the consequentials hearing when Mr. Williams is reported as saying, "I've got some very limited points and I'm going to sit back." I think
that could have been construed, generally, but he was at that point only dealing with the other non-substantive cost points. That was not us.
I think we just need to understand that a little better, because the so-called non-substantive points were relevant to the same order, as in the order of no order for costs, and the transcript certainly can be read as coming across as saying, well, actually, I know you've expressed a preliminary view about no order for costs. These are the points I want to make in response. One is about Part 36, which I think was responsive to a submission of Mr. Carl's. May have misunderstood that. And the other is a small point about pre-action protocol. Have I captured those fairly?
Can I let Mr. Williams deal with that, if I may? Because
I don't want to take you out of order.
Not at all. I'll come back to the point I was making, but as trial counsel, it's easier if Mr. Williams does. I'll get to sit and let Mr. Williams pick this up.
My lady, you are right. At that stage, there was a series of arguments over costs. It wasn't necessarily in relation to Mr. Limbani. There was a series of arguments between particularly Mrs. Edwards and their offers, and it was quite clear at the time, and in my mind, even when I look back and read back, that we were dealing with, you're right, the pre-action protocol point, which came latterly, but also we were only dealing with previous judgments, interlocutory hearings, the Part 36 is at no stage. And that's why I sat back, and the judge, I said back, it wasn't really anything to do with Mr. Limbani, and you can see the judge records that. That's why I pulled back and said so, because it was nothing to do with the main costs point, which...
Okay, so your understanding was that you were sitting back while Mrs. Edwards and others had a debate.
That's right.
About earlier costs orders and the like. Yes. And earlier correspondence.
Yes, and there was a lot of it between the parties. There was a lot of toing and froing about Mr. Cole's non-compliance with some cost orders, the monies that were outstanding, interest, offers. All of that was dealing with previous matters. It wasn't dealing with the substantive matter of the costs at trial at all.
Mr. Williams, can I ask you, I think when the judge, 5-6 months on from handing down his judgment, comes into this consequential hearing without anything in the nature of a list telling him what's on the agenda, it's quite a challenging task. And of course, the judge knows nothing of your position in advance of that hearing, only what you choose to say at the hearing. And just wanted to get your observations on that. But there was no skeleton or even an outline of the points that were going to be taken, was there?
My lord, that's right, but I did request whether a skeleton argument, he wanted a skeleton argument. I simply said a skeleton argument to help, he didn't want one.
So where was that request made?
Yeah, that's...
Yeah. I made a note of it, hang on.
Yeah, sorry, my lord, I am right.
No, I just don't remember the reference.
No, it's a shame Mr. Lee's looking for a reference from me.
Well, when someone finds it, it's fine. Don't let me interrupt.
But my lord, on the basis, we'll come to the reference shortly, I hope. If not, I'll have to come back to him. I'm sorry. It was during, before I even got to say about the substantive costs, my lord, I'd already seen that.
No,
It must have been live in his mind because he already told us. Oh, by the way, just to let you know before we
Mr.
get
Carl
to
raised it in his submission.
yes, just to let you know before we get to it, Mr. Williams. So it must have been in his mind because he told me you're not getting your costs even before even that was much further up in the transcript. You could see and thought, oh, hang on. So it was in his mind that he wasn't going to give me my costs. I didn't say anything at that time because I was waiting to make the observations. Which did you find it?
Yes. In our skeleton, paragraph 21, internal page 5.
So which skeleton is this?
Our skeleton, the appellant skeleton for today, the one that I prepared with Mr. Williams.
Yep.
Paragraph 21, it's just after the extracted quote that I was about to deal with. You get a heading, the miscellaneous fresh points, paragraph 21. That's a reference to paragraph 8, my learned friend skeleton, the 5-month interval. This point doesn't exist, that's my learned friend's point about skeletons. No skeleton arguments are directed by the court. That's confirmed at pages 56 and 57 of the supplementary bundle.
But that's a reference to the January hearing itself. It's not a reference to some direction given by the judge in advance. I mean, the ship had sailed by that point.
Well, because if I may just press your lordship a little more,
Of course.
down the bottom of page 56, Mr. Williams had stood to deal with a point. Can I assist you with this? The judge says yes. Mr. Williams, I wasn't aware I needed to provide a skeleton argument for the purpose of today. The judge says no. Secondly, my lord, I say this with respect to Mr. Carl, I consciously did not do a skeleton for the reason I say respectfully. It seems to have turned into more of an argument in witness statements, generating paper which is unnecessary. The third point, my lord, Mr. Williams says, which actually I have not seen it before, that would be pretending I am cleverer than I am, which I'm not. The third point is that you will see right hassle, my lord. I just point out very quickly for the benefit of Mr. Carl, I asked the training solicitor not to put in the whole of the judgment, yes. But my lord, Mr. Williams continues, para 8 makes absolutely clear the standard of law is the same for lawyers and non-lawyers, etc. So the point is that the judge was acknowledging that there'd been no request by him. Particularly that point. I mean, it proves a negative, but it's the acknowledgement. The judge had not requested skeletons. Obviously, the judge must have been aware he was turning up to deal with...
How long was the hearing listed for?
The consequential hearing?
I'm not too sure how the listing went. I think, my lord, it went on for about 3 hours.
Yeah.
I could be wrong, but don't quote me.
I mean, the Business and Property Court's guide gives default directions for skeletons for hearings of up to half a day and over half a day.
My lord, you're right. My lord, but I stand by my submission there. I'm sorry, I did remember asking about skeletons. The point was, whenever a skeleton went in, it would generate 4 or 5 skeletons and arguments backwards and forwards, which was, my lord, but that was on the context of the trial. It just used to continue to have these side shows. But my lord, no, I didn't do a skeleton. I simply say he was well aware of the points. I know you say, well, Mr. Woody would have helped him in advance, but he fundamentally knew what that he had.
Well, when a judge gives out preliminary views on costs, very often they do it in the hope that the parties may think, well, I'm going to narrow the issues in the light of that provisional view, but parties can say, no, I think you've got the judge's provisional views wrong. What the judge didn't know going into that hearing was what Mr. Limbani's reaction was to the view expressed in the August judgment, did he?
My lord, that's correct, but I was extremely well prepared to make my submissions, and even my skeleton arguments. I said it's just as unattractive to go to the Court of Appeal and say, this is what I would have said or could have said, but because I wasn't allowed to say it. There were some fundamental points I wanted to point to the judge in his judgment, just on the issue of costs. And I accept the point before, Mr. Woody, you can't appeal findings when you've actually won. And there was some fundamental points which I have no doubt could have assisted the judge in.
Well, you do. The fog of war, alas, very often blows across events of this nature. Was this a remote hearing as well, the January one?
Yes, it was.
Yeah.
Yes, it was.
So, my lord, my lady, hindsight, of course, is always 20/20, and it's no one will be surprised for us standing here to say, well, had everybody actually turned up with some fully reasoned submissions, pointed out what the judge had said and perhaps pressed the point a little more firmly, maybe the trial judge might have taken a different view. He didn't, and ultimately he was the trial judge. Whatever counsel did or didn't do, which was or was not the best as opposed to the most reasonable thing to do. What's quite clear is the judge had made a provisional view, had said he would hear submissions on it, and then didn't. And that's why I took your lordships and your lady, my lady, to page 5 of my bundle for the extract, because this is the mot juste, as it were. The judge says, hang on, Mr. Carr, Mr. Williams, have you finished on Mr. Limbani? Mr. Williams, no, my lord. I do not know, because it all depends on your lordship. Your lordship, you've said that you're not minded to revisit no order as to cost. So there we are.
Can we just, on that, do you have the reference in the transcript for that earlier reference?
Which earlier reference, my lady?
As Mr. Williams or yourself has said, there was some earlier reference which he's adverting to here in the transcript where the judge says he's not minded to, words to the effect, he's not minded to revisit. I assume we have that somewhere, but I'm not
transcript is in.
I know where it is. It's in the supplementary.
Yeah, page 27.
Let
me just see, my lady. I need to.
Can I help? Look,
yes, please.
I think the reference that my learned friend is trying to bring you to is in the supplemental bundle at the top of page 50.
Thank you.
Where Mr. Carr and my client
Yes.
are trying to make submissions, and the judge responds to that.
Thank you. That's very helpful.
Thank you. Thank you, Mr. Brannigan. Yes. So.
Yes, that's
Yeah.
That is it. Thank you.
Yes.
That's helpful.
I think you need to pick it up page 49, don't you, at F, where Mr. Carl puts on the agenda, the court has already decided this question of costs, and then the judge responds.
Yes, well, what's happening is that Mr. Carl is making submissions to the judge, at the end of which he gets to the stage where he said, well, you've said there's going to be no order for costs against Limbani, because that's what you've already decided.
Yep.
If Mr. Williams disagrees with that, his remedy is the Court of Appeal. So Mr. Carl, as it were, seeds the judge's mind with that thought. And of course, the judge then says, and I would say frankly mistakenly, okay, well, I'm not about to revisit my judgment. Of course, with respect, he's misunderstood that he hadn't adjudicated on the point. He'd only indicated a provisional view with submissions to be made. Unfortunately, Mr. Carl has plainly misled the judge, and the judge hasn't gone back to remind himself what he said. And in, as your lordship put it, in the fog of war, at a remote hearing, Mr. Williams, having been told the door's shut, didn't have a go at shoulder barging it, just to say to the judge, well, actually, can I take you back to what you said in your judgment? You did say this.
Mr. Williams, he does ask the question 3 times.
Well,
so
my lord, I did try.
yeah.
Yeah. So this is how the judge comes to deal with this point. And so, my lady, that picks up the point I was making. The actual extract that I've put.
Yes, we've got that very clearly. That's on page 5.
Yes, and so repetition, the point doesn't get any better, and frankly, if it's bad, it's bad. But as helpfully now elucidated with the comments from the bench, we can see what's happened. The trial judge has given a judgment, a very long judgment, most of which has nothing to do with Mr. Limbani. Somewhere in the judgment, for his own reasons, which he doesn't adumbrate, he decides provisionally he doesn't want to grant any cost to Mr. Limbani, but says quite properly, well, this is a provisional view, we'll return to it. Many months later, he returns to a remote consequential hearing with a litigant in person who's lost some, won some, who's just told the judge, we've already made your mind up on that point, so that's the end of that matter. And in the heat of the moment, the judge has closed his mind to what he'd actually said. Mr. Williams tries, as hard as one could professionally without irritating the court, tries to say, well, I want to address you. It makes it clear, I want to address you on this point. So this isn't, he hadn't thrown anything away. It was quite clear he wanted to deal with substantive costs. And the judge says, no, go elsewhere if that's what you want to do. And that's what happens. And so on this second area of our appeal, having dealt with the substantive one, there simply wasn't a decision. As a matter of fairness, the judge completely, and we say unfairly, shut down the ability of Mr. Limbani's legal representatives to make submissions on a crucially important matter at the end of a trial, costs, and in the process deprived himself of what might have been germane issues that could have influenced a decision on costs. So he thought he'd made a decision, he hadn't. He doesn't receive anything from anyone regarding the exercise of discretion, and then affirms an earlier decision, which was not actually a decision at all, but an indication of a decision. And therefore, the points my learned friend makes about you made lots of submissions, we didn't make any submissions on these points. And the judge, in any event, even if we had said a nay or otherwise, if a judge is going to make a cost decision of this enormity, a 7-day trial, 6-figure costs incurred, someone brings the case really because they wanted someone to give evidence against other defendants rather than in and of themselves having an issue with the claimant, it was incumbent on a judge to have identified, which we know why he doesn't, because he thought he'd already made his mind up, but nowhere. And transparency, of course, is a touchstone of justice. A decision maker can make a decision, that's the honour given to a decision maker. But those whose lives are affected by the decision maker's decisions are entitled, even as informed listeners, to at least a basic understanding of why the decision was adverse. And the problem in this case, for the reasons I've said, I reiterate succinctly, there isn't anything identified in the adverse points found, which we wouldn't have appealed because they were of no use to the case. There's nothing in there which says, oh, well, this is why cost. This isn't egregious misbehaviour. This isn't someone who brought the case on themselves. This is not someone who lied to the court in a way that lengthened the trial, that created issues that weren't there, that took time up, that wasted the court's time. If anybody, frankly, wasted the court's time, it was Mr. Carl bringing a claim against the driver of 2 of the other defendants because he happened to be their driver, and Mr. Carl thought that might encourage him to give him some evidence which apparently wasn't there. And if the judge had, in any of that behaviour, whatever he thought about Mr. Limbani, if he genuinely thought Mr. Limbani was hiding the truth, which was relevant to Mr. Carl's case, that he'd converted the property or was part of the conspiracy to do so, he could have made a finding. It's perfectly open to a judge to say, you haven't given me any information, Mr. Lee, in relation to this case. Ergo, I am going now to find against you because I think you're hiding the missing information and I've enough suspicion on balance to help me,
Yeah.
etc.
So earlier in the judgment, when he comments on Mr. Limbani as a witness,
Where is this,
pages
my lady?
90 and 91 of the core bundle,
1991.
can we just look at that? Because the point you're making now is that the judge didn't make a finding that relevant to the case that
Yes.
that Mr. Limbani was hiding things. Sorry,
Yes.
I'm probably not giving a fair summary to what you said, but I just want to have a look at what he actually said about Mr. Limbani, which
Yes.
isn't restricted to the cost finding, of course. And there are some comments on pages 90 to 91. In summary, the explanation in relation to the wife was unconvincing. 154, Mr. Limbani was an unsatisfactory witness who clearly knew a great deal more than he was prepared
Yes.
to disclose. How does that sit with what you have just said?
It sits completely with it, my lady, for this reason. First of all, in this long judgment about umpteen defendants, it's not till we get to page 60 of the judgment, paragraph 152, that the judge even gets to Mr. Limbani. And then when we get there, there are 3 sparse paragraphs dealing with Mr. Limbani.
It doesn't end there, though, does it? If one goes forward to page 174, the case at trial against Mr. Limbani crystallises on 2 matters. There's the question of involvement in the raid, as it became known, and after the raid. And Judge at 380 picks up the account apparently given to Detective Constable Lucy Robson when she rang the telephone number for Vic.
Yep.
And the judge is saying there that whoever was speaking on that call is giving DC Robson a description of vehicles having been removed in which removal they were involved. That would have been a highly convenient description for Mr. Edwards, and in effect, the judge concludes that that it was Mr. Limbani who spoke to DC Robson, and that the reason the cars were described in a way that was convenient to Mr. Edwards was that Mr. Edwards had put Mr. Limbani up to it. He then finds the evidence of Mr. Limbani about the conversation unsatisfactory at 382, but concludes there's not enough to conclude that Mr. Limbani was actually involved in the raid. He may well have been. So let's not, say that this was a absolute clear-cut success for Mr. Limbani, although he triumphed in the end.
Well,
and then just going forward, we've got conversion of the 959 after the raid, and the judge found Mr. Limbani's evidence was untrue in parts, but insofar as he was involved, he was acting, as it were, as the instrument of Mr. Smith, and didn't have sufficient possession of the vehicles to trigger liability in conversion.
yes.
So a legal, technical answer that the judge identifies for Mr. Limbani's benefit. I don't know if the point was made in closing submission, but I think those paragraphs say quite a lot about Mr. Limbani.
Well, my lord, they do, but they don't go anywhere. Importantly, and bringing together what my lady says and what your lordship says, what's important is what the judge actually said in terms of a conclusion, because it's those conclusions which might be relevant to the question of costs. Costs are not a way simply to paint someone into a corner and say, I don't like you because of whatever, and I'm going to punish you by not giving you your costs back.
Indeed, then they're obviously not that, but you're making a much more narrow point about the ability of judges generally to take conduct into account. And I think you're saying it's only if they had a material result on the facts. And one way of portraying this is that, yes, the judge didn't make findings about directly adverse to Limbani, but there's some fairly strong signals that led to a result that he was liable in conversion. But there were several strong signals here, including that Mr. Limbani wasn't telling the truth. Are you saying that's irrelevant unless it produces a positive result? Because, and that would be another way of saying you could only the costs would have to follow the event, whatever happens. But that's not what the rules say, and the rules, no doubt, you'll take them take us to them and any authorities, but you would need to persuade us that the ability to have regard, for example, to conduct is restricted in the way that I think you're submitting.
My lady, our submissions are not to say that in some way a judge is generally constrained in the wide discretion we know they have under 44, CPR 44. What I am saying, though, and this is crucial, is if you're going to make a decision in which you have a wide discretion bearing on costs, the material considerations that you take into account when considering costs have to be material. They may be part of a judgment you've given, and they may be part of findings you've made, but they have to be material to the question of costs, because what's being done here is the judge is punishing Mr. Limbani because he won a case after 7 days into which he was brought by the claimant because he wanted to twist his arm to give evidence for him. And then hundreds of thousands of pounds later, the judge says, right, you were brought in because he twisted your arm. You wouldn't have it twisted. I don't think you were forthright. I don't even think you were honest or entirely honest. And now I'm going to make you pay for that. The fundamental switch point, and I'll come to this, the authority on this, is the loser pays. And it has to be an important material consideration for displacing that. And if I now go back to all these passages your ladyship and your lordship has taken me to, can we just remind ourselves, it's important. He gets to Mr. Limbani at paragraph 152, says 154, Mr. Limbani was an unsatisfactory witness who clearly knew a great deal more than he was prepared to disclose. Maybe. Maybe. But one's bound to say, so what? What has that got to do with the carriage of this trial? Mr. Carl framed the action against him as someone who was involved in certain wrongdoings. That's what the case was about. Not in and of itself whether Limbani was an unsatisfactory witness, but the judge could have said, and because he was unwilling to be honest in my view, that inhibited or that prevented the claimant or that caused the claimant to spend more time, go down a path he didn't have to. In the example, some of the cases my learned friend refers to, and I needn't turn them up, the lordships would, the ladyship would have seen these, cases where people exaggerated their personal injury. As a result, at trial, there was time spent with experts having to look at videos of people claiming to have been more seriously injured than they were, interviews with them, etc. In all those cases where the courts effectively said, you've exaggerated, or in some ways you're wrong, the point is the court can always pinpoint, and because you've done something you shouldn't have done, that has had cost consequence. But quite robustly, my lady, if something that a party does in a case does not in any way jeopardise the other party's ability to prosecute that claim, or in some way impede justice, or lengthen a trial, or cause some other cost, it would be wrong, certainly in principle, to have costs not awarded against them without the judge actually saying so. The judge could have said, although in this case Mr. Limbani did not lengthen it, although he did not cause any material side issues to be generated, although he did not prevent Mr. Carl from prosecuting his claim, nonetheless, I find Mr. Limbani such an unsatisfactory character, remembering he only saw him for 1 hour on the screen. I find him to be such an unsatisfactory character that it's so egregious in this court that I'm going to sound it in costs. He could have said that, but he didn't. What he did say was much more limited. Page 91, Mr. Limbani at 154, unsatisfactory witness. That's it. We get to page 174. Mr. Limbani, represented, etc. Para 379. Two issues
yes,
which
we've got what the judgment says.
well,
In
it's
terms of how
important
this
though.
plays out, Mr. Limbani is not originally a party to these actions. Mr. Edwards, trying to explain what has happened to cars, says they were delivered to a location in London on the instructions of someone called Vic, who he described as working for Trevor Smith, and he provides Vic's phone number. This is para 64 on page 57, which is Mr. Limbani's phone number.
Yeah.
DC Robson then phones someone on that number to be told, I moved a number of cars, including various cars for which Mr. Edwards is otherwise obliged to account. This is all happening before Mr. Limbani is joined to these proceedings. Mr. Limbani's line is, all I ever did with Mr. Edwards is giving him a phone number and drove him around with Mr. Smith a couple of times. Judge finds, I'm afraid, that largely is an untruthful account of his true relationship with Mr. Edwards, and that the account given to D.C. Robson on December 2015 was an account given to serve Mr. Edwards' purposes and untrue. And it's against that background that the claim is brought against Mr. Limbani. And I think an obvious question arises, well, is it understandable that Mr. Limbani might have been identified as a relevant defendant against the background of facts like that?
My lord, no, for this reason. In effect, what the judge says is, notwithstanding whatever Mr. Limbani says, and taking into account the hearsay evidence that he admitted that the previous judge had said shouldn't go in, he says this: someone makes a phone call, which I suspect was probably Mr. Limbani, not that he would admit it, and Mr. Limbani moved a car around. Again, so what? Even if someone moves a car around at the instruction of someone who may or not have been involved in some kind of conspiracy, importantly, my lord, and this is at page 176, paragraph 383, the judge says, I don't think the evidence before me is in any way sufficient to enable me to conclude that Limbani was actually involved in the raid. This was concerning chasing the Lamborghini Mayura, the Ferrari F40, the 959, and any other cars, that the exotic cars that were on the shopping list.
He may well have been.
He may well have been, but there's insufficient evidence for me to conclude on the bounce probabilities was. Now, that's as far as it gets. He thinks he might well have been involved. It was open to the judge, as a matter of the judge's judicial decision-making, to say, I think he's such an untrustworthy character, a dishonest witness, whatever words he wants to use, polite more than I've just said. The judge could have said, I think that you were part of the moving around of the vehicles that were being hidden from Mr. Carl, these exotic cars that were being moved around. You were involved in it. You were actively. But there's a difference between actively involved in it, in the sense I'm going to make you liable, and being someone who happens, even on the judge's version, who happens to have moved them around. The judge could have gone further. Indeed, some might say, well, given his other findings, he could have done, but he didn't. The fact that the judge found Mr. Limbani was not part of this.
Well, he wasn't persuaded on the balance of probability that he was.
And that's what the law says. And therefore, if the law says, I've got to be satisfied on the balance probabilities and I'm not satisfied, even if I don't like you, I'm not satisfied, it's not, in law, open to a judge to say, well, even though you got off, I think you're going to get punished. I'm going to make you pay the six-figure sum of costs. Because this isn't a court, it isn't a court of morals. It's not a court to work out between a bunch of people, or even between, on the judge's version, a bunch of villains on one side and someone who was duped on the other. Mr. Carl brought the claim in English law and is bound by English principles. One of those principles is, if you bring a claim against someone and you don't succeed, the starting point is you have to pay for that other person's costs. And if a judge is going to disturb that time-honoured principle, then at least he has to articulate reasons beyond which we've looked at here. Because with respect, we're scratching around here to find adverse comments from the judge. The judge didn't like him. I'd make that absolutely plain. Mr. Limbani was a man who failed to impress, in the 1 hour he was on the screen, the judge. And the judge had other documents he heard from other people. And again, I make that rather pithy but rather relevant point. So what? It would have been open to the judge to take a different view. He didn't. And even if he was taking a view, it was at least incumbent for the judge, when deciding costs, to say, well, these are my reasons, I'm going to punish him, which is what he's doing. Because if one looks at the cases, that's the circumstances where you don't get your costs. You've either wasted time, brought the case upon yourself, caused the hair to be run off in a different direction, or in some way a court wants to visit on you a punishment for being involved in a case which you've won, but which for some reason the court decides otherwise. None of that's identified by the judge. We know why, because unfortunately he was misled probably by Mr. Carl's submission that he'd already determined the matter, when in fact he hadn't. He'd actually said, I want to hear submissions on it. And we've not even had the chance to make those submissions. And if one does make those submissions, my lord, as soon as one looks at this, there isn't anything there. There's nothing there, even collectively and certainly not individually, that says, why should Mr. Limbani pay costs, even if one puts it in this inelegant fashion? The judge thought Mr. Limbani was dodgy. Being dodgy in and of itself is not a reason to say, and because you're dodgy and because you had a lawyer acting for you, and that lawyer did a case so that I wasn't persuaded you'd done anything wrong, there is no basis in law for a judge to visit costs against you. It has to bite on something. This CPR 44 discretion isn't wide. And that's why they're two short judgments, but they're very useful. This is tabs 11 and 12 of the cases. These are the ones that I drew attention to. Dorman, tab 11, is really the obvious point, I would say, but nonetheless one worth stating. That, and I believe I did sideline them, yes, page 192 of our bundle.
I haven't got, for whatever reason, my authorities bundle doesn't have those. I'll look at them online.
Right. They should have accompanied. I sent them to your clerk, my lady.
Yes, but unless you actually say they need to be printed out, the assumption is they will be. But I've got Dorman online, so
yeah.
So you rely on Dorman. Which is the other one?
Dorman paragraphs 53, 54. I've sidelined the relevance.
Yes.
And then the other one was the Hackney.
Hackney. Yes, I thought so.
Apologies.
I've got that as well.
And again, paragraph 10, sideline. I don't need to rehearse them at any length with the court, but the point is that and now I'm straying into reiteration.
Well, so Dorman is on. That's on fairness. Are these both on the point about fairness?
No. Hackney is about the point that the general principle point that
yes.
If you're going to disturb the general principle,
okay.
there has to be a good reason.
Right. So you've sidelined 10, which is effectively that who won. Is there anything else?
It's a short point. We won.
Okay.
It's commercial litigation.
Okay. One thing I'm conscious of, Mr. Lee, is by the end of your submissions, we would want to make sure we've got your arguments, if you like, the arguments that Mr. Williams would have put to the judge if he'd been given the opportunity.
Thank you, my lady. I'll deal with that in two ways.
Yes, I think because at the moment we're covering both points.
Yes.
You've covered both points to some extent in your submissions.
Yes.
You've covered the procedural fairness point.
Yes.
I suspect as fully as you want to, but I also want to make sure that, let's say, for example, we were with you on the fairness point. The obvious question then arises as to whether we should exercise the discretion. So yes. One way or another, by the end of your submissions
yes.
and Mr. Williams' submissions, we need to make sure we've heard you on that point. And we've heard quite a lot, but it may be that you want to make some more points.
Well, on the basis that Mr. Williams effectively is given that second opportunity that he wasn't given the first time round, I'm certainly going to let him make the points at the moment. But you've got my substantive overarching point.
Yes.
I'm somewhat dismissive. Yes.
We've got the you won.
That. Well, it's not just we won, and the judge didn't make any finding.
Yeah.
That's the important point. It's very easy, I say with total respect to anybody that looks at this, to say, oh, I know why the judge did it. He didn't like your client. And I sense, and I'll let Mr. Williams speak in a moment, but I sense that the difficulty that I'm facing is the concept that a judge can, as it were, not give someone their costs because, in short, they don't like them, in particular, that they either told lies or they weren't wholly truthful or there was more than met the eye. And I go back to a fundamental point here, and this is perhaps an important legal point. When one is considering costs, the court does not actually have carte blanche in the sense you can do whatever you want. As I say, a court, I mean, absurd examples make the point, but the court will understand. A court can't, it cannot be exercised whimsically. So if the court felt, well, today the sun shines out, I'm in a bad mood, I'm not going to give costs. In theory, one could say, well, it's in his discretion. But I go back to the point, and this doesn't appear to be a contested issue. And it is in some of the judgments. Hopefully I don't have to take your lordships and ladyship to the particular passages simply for the sake of time, but it's plain that the court takes into account relevant considerations. It's a bit like an administrative law point. A decision maker, the Stringer, Minister of Housing and Local Government, famous Lord Denny judgment, you take into account what's relevant, you eschew what's irrelevant, you are to be treated as a reasonably minded, properly informed decision maker, and you don't act perversely. Now, that, or those overarching, well-known public law principles apply equally to a judge making a decision on costs where they have, on the face of it, complete discretion. In practice, they don't. It has to be exercised in a judicial manner. And we have to emphasise that. Otherwise, there's a risk that we are going to be faced with, well, judge didn't like you for various reasons, to which I say, so what? But if a judge is, can make decisions on their own, ipsy dixit, whatever's influencing that day, particularly when that's not set out for anybody to consider, which it wasn't in this case, one would have a very unfair system. I suspect that is trite, but I emphasise it.
We're very clear about the basis on which cost decisions can be disturbed and appealed. Thank you.
Thank you. I'll let Mr. Williams say what he
Yes.
might have said had the judge not told him to sit down.
My lady, I'm grateful. My lady, the way I see the judgments, the way I saw the judgments at the time, there was 5 headings, and these are the 5 headings which, the way that Mr. Limbani got criticised, and it crystallised the 5 points in this way. 1 was disclosure. 2 was evasiveness. 3 was court orders. Failure to comply with court orders. Then a very small point, the Part 35 report, where you could see that the medical expert said he's very poorly. I'll come on to that.
So is that one of your headings?
Yes. And then number 5 is the judge made there was a finding in there that Mr. Limbani ostensibly not engaged with the litigation. I'll deal with that point first. We don't understand what the judge means. I never knew what he meant when he said he failed to engage with the litigation. That was one of the points, and to do that one first, I wanted to engage with the judge and said, that's simply not right, Judge. Irrelevant of your findings, we're dealing with the issue of costs. My lady, your lordships, if I could deal with point 1 first, please. That's in relation to disclosure, because it was criticised, obviously, in the judgment. I don't need to take you to it.
Yes.
He was criticised for failure to disclose. Well, this is very important. My lady, your lady and your lordships, if you could look at this point, in fact, Mr. Carl, when he struggled with disclosure, was not alien to making applications for disclosure.
Can I just get one thing straight? Because I know you've made it very clear that there was no order, no application or order for specific disclosure.
Yes.
But The judge certainly proceeds on the basis that disclosure was ordered against your client.
Yes.
Is that correct?
Yes.
Right.
I could deal with that without any problem, I believe. But by way of introduction, to emphasise my headings, if you look, please, at the supplemental bundle, it's page 10. In paragraph 21. You will see that that is in relation to another defendant. So he knew, Mr. Cole knew about the point about making specific disclosure applications. My lady, then, page 11, paragraph, forgive me, paragraph 26. Again, you see the application notice dated the 9th of May 2021 against the fourth defendant. Pausing there, I don't believe this is contentious, so you could see the date, my lady. If you look at the date of that order, you will see that's on May 21, 17th of May. So at that stage, some 3 years prior, Mr. Carr was aware if he wanted documentation, specific disclosure, how to do so. And it's not in contention, my lady. And thereafter, after that order, it's not in the bundle, my lady, but Mr. Carr made a Part 18 request of my client, to which he answered. So I say, whereas I couldn't appeal the findings of fact, because we won, I wanted to engage with that to explain to the judge, hang on, judge, or my lord, you've criticised us for being evasive on disclosure, but actually there was no application for disclosure, and we did in fact comply with our disclosure obligations. My lady, you've already seen the point where I was discussing about the pre-action letter. I said it wasn't worth the point taking any further. I simply said to the judge, and it goes on to my next point as well. Oh, sorry, I wanted to say to the judge, where he says in his judgment, he says this, and only dealing with the issue of cost, not stepping outside of that sphere of cost. Core bundle, page 204, paragraph 23.
Right. So are we now on your point 2 about evasiveness?
Oh, sorry. Yes, this is in relation to evasiveness.
Yes.
I do apologise. The fourth line down, it seems extremely unlikely that Mr. Limbani would voluntarily have responded to a pre-action letter at a time when his main objective seemed to be to avoid engagement. Pausing there, my lady, that is a finding which none of us could ever understand, because at the point of when we said he should have served a pre-action letter to put us on notice, Mr. Limbani knew nothing of the proceedings. He knew nothing of the proceedings at all, and it's compounded, and I can support that proposition quite easily. I am going to, but I just want to deal with 2 other points before I finish on that point. Page
so
1.
you say you didn't have any basis to conclude that Mr. Limbani's main objective was to avoid engagement?
Yes, because he knew nothing about it, and I could deal with that head on and prove to this court, and would have been before the judge, that it's wrong. My lady, if you go to page 194, please, page 433.
Sorry, 194.
194.
Call that.
Yes, the core bundle.
Paragraph 433.
Yeah, sorry, paragraph 433, 194. Where he says he has escaped examination of his conduct through a policy of evasion and non-disclosure. That's simply incorrect. He did comply with his disclosure obligations, and secondly, there was no application for specific disclosure.
Well, let's be clear. So when you say he complied with his disclosure obligations, what I at least have picked up from the judgment is that what he did is come back and say, I've got nothing to disclose. Is that correct?
Mr. Limbani's position is, and always has been, I had nothing to disclose. There was no documents to disclose. He never had any documents to disclose. All he accepted, there was some phone calls, which he never denied. He had nothing to disclose.
His wife's bank statements would have showed the £500 a month going in with and the invoices of storage. Is it said that those weren't documents for Mr. Limbani to disclose?
Well, Lord, asking me a question, I have to answer it. The position at the trial, it seems I have to answer you. Position at the trial, but there was no issue that Mr. Edwards' wife, Mrs. Edwards, was actually in contact on a very loose, friendly basis with Mr. Limbani's wife. I'm not going to stand here and even contemplate misleading. But our position was what the arrangement that Mr. Edwards had with Mr. Limbani in terms of some part-time jobs, taxi booking, etc., was of limited value. But my lord, I accept.
But the payments had the legend storage, not the legend secretarial services.
But my lord, I accept that point. But if I could just finish, because I'm going to address it directly. What you have to remember, my lord, is this, that the next point in relation to court orders, which does touch upon what your lordship said, is this. The judge finds that we didn't comply with court orders and we didn't engage in the litigation. That's not true. What happened was, there was no pre-action protocol as we now know. There was a judgment against my client because Mr. Carl served it at an incorrect address. Judgment then did come through to his home address. Judgment in default was set aside. He files a defence, he engages with the entire process. So for the judge to make a finding that he didn't deal with court orders was simply wrong. Mr. Limbani absolutely did comply with court orders, and to the contrary, which I wanted to point out to the judge, there was 6 different occasions, at least, where Mr. Carl did not comply with court orders, including the adjournment of a trial. There was consistently and continually applications before the court at the interlocutory stage. I think, forgive me, I think there was 3 times an application to strike out Mr. Carl's case because of his non-compliance. So, my lady and your lordship, these are the points I wanted to make to the judge. The disclosure point, which in my submission would have had some force. Judge, may I just remind you that Mr. Carl had made specific disclosure applications against 2 other defendants.
Well, can we just go back to that? Because are you saying that absent a specific disclosure order, there was no general obligation to disclose? I don't think you are saying that.
No, I'm not saying that. No, I simply said my instructions always were and have been that Mr. Limbani had nothing to disclose.
What about the points raised by my lordship's
My lord, I'll have to turn my back in a moment because I'm not too sure where that statement came from, when in fact it did, where it did come from. But the bank statements, I accept what my lord says.
Yeah.
It's a question that needs to be answered. But when you put that together with the evasiveness, we say he wasn't evasive. In fact, he did engage with the entirety of the litigation. He complied with all court orders. He gave his witness statement. And my lord, if I could please then just take you to another point. And this is one of the problems that we had at trial. Again, I wanted to point this out to the judge. It doesn't fall necessarily under one of those headings, but it's important. Again, back to the same document, the same order in the supplemental bundle. My lord, in relation to the page 10, internal page 10, paragraph 19, this is what had been ordered.
Sorry, where are you? Which?
The supplemental bundle.
Supplemental bundle, page 10. Yes, paragraph 19. Thank you.
We were faced at trial where the trial judge, essentially overrode this at trial. We had no opportunity to deal with. Paragraph 19, the claimant's application to require the defendants to serve hearsay notice in respect of their witnesses for trial is refused. If the claimant intends A, to provide notice under CPR 33, then he must do so. To cross-examine the makers of hearsay statements, he must do so by application.
Mr. Williams, I think there may be some cross purposes here. This was an application by Mr. Carl to require the defendants to serve hearsay notice in respect of witness statements they intended to call. Now, as the judge said, CPR 33.21a says if the hearsay is contained in a witness statement, you meet the notice requirements simply by serving the statement. So that didn't arise. If you make a hearsay statement, the other party has the ability to tender a notice, effectively say, I'm going to challenge this evidence. And I want you to call the witness so I can cross-examine them, which is what the notice under CPR 33.5 is about. None of that is anything to do with hearsay evidence being admitted by Mr. Carl.
My lord, the point is that in relation to the hearsay statement of P.C. Robson, there was no application to call P.C. Robson. There was no hearsay notice either.
No.
But that doesn't relate.
It doesn't make it inadmissible under section 2.1 of the Civil Evidence Act.
Except it doesn't make it inadmissible, my lord. But my point was this. It comes on to my next point, is that when you look then, and this is what is highly unfortunate, if you then go to a supplemental bundle, page 19, yes, that's the medical report, my lord. And you will see the summary of the executive. So I'm not going to read it all out, but you can see that Mr. Limbani, at the executive summary, is an extremely poorly man. You can then see over at page 23 the diagnosis and opinion. He had to give evidence from his sofa at home with the solicitor sat next to him. It was either that or he didn't come to court because he was so poorly. When we say it's a material consideration to at least note the demeanour of the witness by reference to the expert report, which wasn't challenged in there.
But in terms of, let's take one of the judge's more striking findings. Someone calls Vic, gives DC Lucy Robson an account. It's accepted that DC Lucy Robson phoned Mr. Limbani's phone number. Mr. Limbani's answer is, I might have left my phone in the car, and some other person might have taken the call, pretended to be me, and held that conversation with DC Robson, in which they say that they are me, they work for Mr. Smith, they were involved in the removal of 5 vehicles and identifying what the 5 vehicles were. judge found that to be dishonest evidence. There is no medical evidence known to man that's going to explain that away with respect, is there, Mr. Williams?
My lord, I can't seek to go behind what Mr. Lee says. What Mr. Lee says, the relevance of that as to terms of costs. Whether the judge would have been persuaded by the point, well, Judge, just remind you that was hearsay. You've made your findings, but let's not forget Mr. Limbani, on anyone's version of events, was a poorly man who'd been put through this litigation. One, he did comply with the court orders continually. You found he hadn't. I'm afraid, my lord, you were wrong. You also need to be reminded in relation to disclosure and evasiveness that Mr. Cole hadn't in fact made any applications. We say he hadn't been evasive, had complied with the court orders, hadn't done anything wrong. And also, my lord, you're wrong to say that Mr. Limbani hadn't engaged with the litigation. He'd completely engaged with the litigation as soon as he found out about the judgment. Yes, one point. I've made my 5 points.
We don't have Mr. Limbani's witness statement, do we? Presumably he did serve one in accordance with the usual directions.
There must have been a witness statement.
Yeah, of course there was a witness.
I don't know whether it's in the bundle with everything else.
I'm not aware of having.
My lord,
We asked could it be admitted, and my friends said that it shouldn't go in the bundle.
Okay, well, I don't know anything about that. If it's something that the decision's going to turn upon, I better take some instructions, but I don't know about it. If you want me to take instructions, if there's a point that's going to tell me you haven't put in a witness statement that the other side wanted us to put in, we're not trying to shut anything out. And I hadn't seen it gone in the unagreed bundle, so I don't know.
But at the moment, I would assume the account was the same as that given in the defence and in the document
That would make
described as
sense.
case memorandum. But
Yeah.
if it's different in any way, then perhaps we should see it. If it's common ground, it's the same basic narrative. I suspect we don't need to.
The point, there's 2 points, if I may, my lord. I just need to, I think, deal with a little bit more. These 2 points, the involvement of Mrs. Limbani for payment, and the other matter about the phone conversation with the police officer. I reiterate the point I made earlier on. Neither of those points, individually or collectively, influence the outcome of the case. At a high point, the judge could have said, as one knows, I consider all of the evidence put forward by a witness or a defendant to be unreliable, and as a result of which I'm going to make adverse findings, because I think what the untruthfulness is not simply untruthfulness because of misrecollection or a fear of saying something one shouldn't say, but is an attempt to mask a truthfulness that goes to a core part of the case. So one knows that witnesses sometimes lie because they're mistaken, sometimes lie for wrong but well-intended reasons, and sometimes they actually lie because they're concealing something which would otherwise lead a conclusion against them being made. Importantly in this case, reminding oneself of the examination we've made of the judgment, there's nothing in anything that the judge says adversely about Mr. Limbani, including the police officer's conversation, including the wife's payment for something or other. None of that, as it could have done, led the judge to decide anything other than Mr. Limbani is not, if I can use the phrase, guilty of what he's been charged with, namely the prosecution of the claim by the claimant was wrongly brought. And it would have to be for the purposes of an adverse cost consequence of the kind we're appealing here, for the judge to have made a specific finding that something about one or both of those findings had an impact on a cost consequence relevant to the trial. Otherwise, they just become immaterial considerations, my lord.
Well, your point about people telling lies, as the judge found this witness did for different reasons, is a fair one. And of course, it's reflected in the Lucas direction in criminal cases. But in civil litigation, a consequence of people telling lies that someone else believes are lies is it can be an engine for the litigation to proceed, precisely because it's believed they must be doing it to cover.
And your lordship makes a very valid point that's not relevant to this appeal. Because had, let's say, Mr. Carl brought proceedings against Mr. Limbani as the central or only character, a judge might have said, well, you brought this on yourself. You didn't cooperate, the answers you gave were evasive, etc. Mr. Limbani didn't start off as a party to the proceedings, came along much later. He's he's defendant 9 for a reason, but he's way down the list. He features in this sorry tale somewhat on the periphery. And the point is that there is nothing Mr. Limbani did or could have done other than, as it were, to take the £5,000 off the costs that he was already in for a large five-figure sum and make up something that Mr. Carl was happy for him to say against the other defendants. We've seen from those emails, Mr. Carl was twisting his arm. I will sue you unless you come and give me some evidence which I think might be helpful. Originally it was in the civil matter as well as the criminal matter. Eventually it was only in the civil matter. That is a classic abuse of process.
He asked for full and frank evidence, in fairness.
Yes, we wanted full and frank. And Mr. Limbani said what he said, and there's nothing in what he didn't say or what he did say that's in the judgment that takes us down the line that your lordship quite rightly makes. If you brought the litigation on yourself, if in some way you've brought the spotlight of litigation onto yourself, even if you're among a bunch of others, but there isn't anything in what the judge... That is why we struggle on this side to say, where does the judge join the dots between these... I'm going to classify them as adverse findings, leaving aside whether they were correct or not. We know the disclosure point, the judge was wrong, for example. And that's important because I would make this additional point. If the judge was setting out his stall, that there were various things that influenced the adverse decision he made, if that's what he was doing, we're trying to piece it together, but if that's what he was doing, we already know that he was wrong on one point, the disclosure material. And given a judge's attitude to somebody who doesn't obey court orders, it's not surprising a judge takes a dim view. If a judge makes an order, we're all expected to obey it. The judge got it wrong. Obviously, we weren't going to come to the Court of Appeal and raise that point because it wasn't necessary, but we're perfectly entitled to deal with the point here. So we have a judge who made a decision on a preliminary basis, thought he had then finalised it, and thereby finalised it, made some findings, some of which were wrong, and it must be said against us, is that a sufficient basis under CPR 44 to make an adverse finding? No, it isn't.
Okay. Is there anything else that you need
Can I just turn my back
to add?
Yeah, I'll pick anything up in response, particularly on the law, but I hope I've now done justice to the skeleton, the way we put our case. Thank you, my lord. Thank you, my lady.
Mr. Brannigan.
May it please the court. The arguments this morning have evolved somewhat from the arguments in the skeleton argument.
Yes.
Most of them I can deal with. It seems to me the 2 points that I'm going to struggle to deal with are firstly the assertion that Mr. Limbani was in the box for only an hour. I haven't got the transcript. I just can't deal with that. I suspect that's not going to make any difference anyway, but I can't deal with it. The second point, which again I suspect isn't going to make a difference, but which I say the court should actively disregard, is the suggestion that the litigation was one made, to use my learned friend's phrase, in terrorem, and that my client never expected in the end to get any damages. If that was a point that was going to be made, that's a point that should have been made in the skeleton arguments and or by way of some further evidence submitted, and not made on the basis of 2 emails which occurred in the run-up to the trial as I read the chronology. But I can't really deal with that as a
Yes,
factual assertion.
those emails were brought while the litigation against
Absolutely.
this defendant were on foot.
Absolutely. And when you look back at the emails, you will note with some interest that one of the very points which my client was trying to get the appellant to give evidence about were these payments to his wife. We can look back at the emails and see that.
I mean, there is the difficulty that one reason why one may not expect to get any damages from anyone is they may not have the assets to pay them. Many an anchor defendant has featured in that capacity.
Absolutely. It's one of the very points. Then, at that point, if I had to deal with it, the point I would make is it's a perfectly appropriate thing to do if you realise that you're not going to get any money from somebody in the end, to try and salvage what you can in terms of cooperation with the claim as a whole. And to describe that process made by a completely innocent victim of fraud as bringing a claim into Rorem is a little unfair. But anyway, I can deal with most of the points which have been made today, and I'll seek to do so if it pleases the court by making my submissions in 3 sections.
Yes. Well, I mean, I'm planning that we break at 1 anyway, so which may give you a chance to get further instructions if there are points that
Certainly.
you've not had a chance to.
Can I?
Oh, sorry. Okay. Okay. Apologies.
Don't worry.
Can we go to 1:15
I
and
certainly
then
can
start
if
again at 2:15?
if that works for the court. I'm perfectly
Yeah.
happy with that. It probably lets me get a little more into my stride, so I'm grateful
Yes.
to the court for that. So the 3 sections I was proposing to deal with are to firstly have a little bit of a more close and forensic look than we've had so far as to what actually happened here by looking at the judgment in a little more detail. And it's clear from the observations the court has made I can do that quite quickly. It's apparent the court has read the judgment. But there are 1 or 2 bits, one of them a little bit amusing given the submissions made this morning, that I want to draw the court's attention to.
Yeah.
In that section, I'll also have a look at the run-up to the hearing, run-up to the consequentials hearing itself, because it's probably useful to see the skeleton, that there was a skeleton argument filed for that hearing. It's just that it was filed by Mr. Carlson months before the hearing. And then look at the judgment that emerged. So that's section 1. Section 2 is to actually look at the law, take out the cases and have a look at the law, including the case from last week. And section 3 will be, having done that, to take each of the grounds of appeal one by one and to deal with them. And of course, I'm happy to jump around as the court sees fit through that. So can I then open the judgment? The court will have spotted that the judgment is found in the core bundle and starts at page 31. The court has obviously seen most of the sections, but it's worth, I think, just pointing out to the court that there's a few more sections in the judgment which are relevant. The first is at pages 64 and 65. 64 talks about Mr. Edwards' witness statements for his committal trial, claims he delivered the cars to location in London on the instructions of someone called Vic, who he describes as working for Trevor Smith.
Sorry, which paragraph are you on?
Paragraph 64, milady.
Oh, I misheard. I thought it was page.
It's my accent. Paragraph 64, page 57 within the core bundle.
Thank you.
And I'll just begin that reading again. Mr. Edwards' witness statement for his committal trial claims that he delivered the cars to a location in London on the instructions of someone called Vic, who he described as working for Trevor Smith. He provided a mobile number for Vic, which is the mobile number for the 9th defendant, Vikash Lambani, who was at the time the driver for Mr. Trevor Smith. Mr. Smith was the 10th defendant in this action, but is now dead. Mr. Smith appears to be another member of the criminal underworld.
Yeah.
Then at 65, and you may see immediately why I describe this as a little amusing. It's entirely possible that Mr. Smith may have lent $800,000 to Mr. Edwards on the security of the cars appropriated in the raid. And if this was the case, it is entirely plausible that Miss Lambani, who was clearly more than merely a driver,
we'd seen that.
may have played some role as an intermediary. I flagged that up because my learned friend, by my note, made the point 7 times in his submissions that Mr. Limbani was merely a driver. And he does so in express defiance, really, of the judge's express finding to the contrary. If we go through then to core page 78, paragraph 126, and it may be sensible to store core page 77 just to start the story. So this is a part of the story to do with the removal of a car called the 959, and
Paragraph?
I'm looking at paragraph 126. And you can see, I think, 1, 2, 3, 4, 5, 6 lines down, there's a line that begins to have contacted. If one just goes to the line above, one or other or both of these cars, you can see that the learned judge finds is this time that Mr. Edwards appears to have contacted, through Lakash Limbani, a car dealer called Aman Thakral, with a request that he sell a Porsche 959. So, again, it's another reference to Ms. Limbani in the narrative. We then go through to the bits that we have seen before and which the court has already discussed with my learned friends, which begin at page 90 over to 91 of the judgment. You can see that what is said, that Mr. Limbani proffered a straightforward Stonewall defence. His position in his witness statement was that he had never spoken to Mr. Edwards about the cars, that he had only ever provided Mr. Thackrell's telephone number to Mr. Smith, and that he had no documentation or communications of any kind to disclose. So we know what's in the witness statement. And we know from the rest of the judgment that significant aspects of that witness statement are simply untrue, because the judge makes findings that is so. Mr. Limbani's cross-examination unearthed a number of issues which were not mentioned in his witness statement, the most interesting of which was a period payment of £500 per month received by his wife out of the account of Mrs. Edwards, undoubtedly made by Mr. Edwards for several months after the raid with the Legend storage. Mr. Limbani's explanation for these payments, that they related to secretarial services provided to Mr. Smith, was entirely unconvincing. That explanation appears to be the same one my learned friend gave you this morning. He's perfectly entitled to do so on behalf of his client, but one cannot escape the fact that that explanation was heard by the judge and disbelieved. That being so, that expression of disbelief in the finding by the judge isn't just a finding as to the chronology, but is also a direct finding of that what is said in the witness statement to paragraph 152 must be wrong. Because the witness statement says he had no documentation or communications of any kind to disclose. And it's that which then leads to the learned judge's conclusion at paragraph 154 that Mr. Limbani was an unsatisfactory witness who clearly knew a great deal more than he was prepared to disclose.
Now, I suppose the technical point might be taken if it's his wife's bank statement, is it his document? I have a sense of how successfully that argument might fare in the business and property courts. But
I probably don't need to make much submissions on that. Obviously, the test is whether it is within his power, custody, or control. And one would have thought that his wife's bank statements, given that on the judge's finding, they are dealing with a transaction which Mr. Limbani knew about and which is directly related to the litigation, one would have thought that a judge would be likely to conclude they fell at least within his power or his control. Putting the point gently, it is difficult to imagine any judge of these courts putting up with an explanation such as that.
Well, you might argue that that's an explanation for the judge's finding that there was a failure of disclosure.
I am
because
arguing
there's no No one so far today has suggested any other documentation that would have been in the judge's mind.
Well, that's absolutely right. The problem we all have, the panel and me coming to this, is that we have to work off the court's judgment. It is clear from paragraph 153 that the judge had in mind a number of issues that are not mentioned, and he has picked what appeared to the judge to be the most obvious and directly relevant example of that.
Yeah.
I think my submission, my lady, on that would be this. One, in a case such as this where one is talking about a fraud, one only does need one good example of an abject failure to disclose. A document which goes to the heart of the allegations, which these documents certainly appear to be. One only needs one of those before a judge is entitled to conclude that there has been a serious failure to disclose. Again, a problem, a challenge for this particular court to deal with this is to deal with the fact that the appellant turns up today to criticise the judge for making that finding, but without ever having appealed the finding.
Well, we have covered that that would be problematic, but it might suggest that something needed to be put, at least that something more substantive needed to be put to the judge at the consequential hearing.
Well, at the moment it's difficult. Well, we've now, and of course I'll come to deal with this in more detail by reference to the law. But we now at least know what would have been put to the judge on the consequentials. Indeed. And you've heard what would have been put to the judge on this point, which is I understood the submissions where, well, the judge should not have criticised Mr. Lambani for this because there had been no specific disclosure application made for these documents.
Well, that point was made, but also I think it went further and said there was no failure of disclosure. That point was made.
Right.
And we've heard your response to it.
Thank you very much. Okay, so we were at pages 90 and 91, and as you are aware, we also have pages 174 to 175. The point which the court has already raised with my learned friend, and I don't think I need to read it out. The one thing to, I guess, pull the point back to the passage we've just looked at. This is a finding by the court. Firstly, that Mr. Lambani was involved in conversations following the raid which were materially relevant. Secondly, as we can see at the end of paragraph 381, it's an express rejection of Mr. Lambani's evidence on this on the grounds that it is untruthful. And thirdly, it is a further, if we go back, if we keep our finger in 175 and go back to page 90, it is a further indication and finding by the court that the evidence put forward by Mr. Lambani in his witness statement that he had no documentation or communications of any kind to disclose is untrue.
Well, he wouldn't have had a transcript of the call.
No, but if we read paragraph 152, he says his position in his witness statement was that he's saying a number of things in the witness statement. He'd never spoken to Edwards about the cars, comma, that he'd only ever provided Thackeray's telephone number to Mr. Smith, comma, and they'd no documentation or communications of any kind to disclose. Well, here is a communication, it's a phone call.
I mean, when one criticises someone for not disclosing in a litigation context, that can have two meanings, can't it?
Of course.
CPR 31 documents, but it also can mean when you give your account of events and you entirely omit from it some obviously relevant exchange or involvement.
And I have to say that whenever we come to it and we read the judge's conclusion when he pulls these threads together and says there's been an active policy of non-disclosure, I submit that the court should read that word disclosure as meaning exactly what my lord has indicated. disclosure more widely than just documents, and an active attempt to not come clean in terms of the involvement of this gentleman in this fraud. Now, all of these things we've looked at, you can see, are communications and disclosures in the sense of telling the court about communications and disclosure in the sense of documents, which go to the heart of the fraud. They're not peripheral matters. They're set out as one goes through the chronology, precisely because the court is going through the chronology in some detail and setting out the role of all the various gallery of individuals. I was going to say rogues gallery, but that's unfair, given the finding in relation to the ninth defendant. But the gallery of individuals who participated in one way or another with what happened. And here you have a number of instances in which the judge has heard Mr. Lambani and has arrived at the view, I don't believe his evidence. He has told me untruths. He has told me untruths in his witness statement, and I think he was directly involved in a number of ways. As we'll come to see, the court said that doesn't mean that he is guilty of the court of conversion. Of course, it doesn't necessarily mean that. But it also doesn't mean, as my learned friend has submitted this morning, well, he was found not to have had anything to do with it, I think was the phrase. That's not what the judge has found. The judge has found that this gentleman has got quite a lot to do with it and has, through the litigation, misled the court about that, but that there isn't enough evidence to find him liable for conversion, which, as this court will know, is a rather different point. So that's what's said there. If we go through then to over the page, at paragraph 383, the court makes the point that I've just made. He goes through paragraph 382. Mr. Lambani's evidence as regards this conversation was contradictory. He talks about what's in the witness statement, then the oral evidence. And as my lord, I think, observed in argument, whilst the court does not say so in so many words, the implicit finding by the court of paragraph 382 was that he just does not believe Mr. Lambani in his explanation as to what happened, as he was entitled to do. And let me grapple head on with the point that's made, and it's a point I try to take from the skeleton. The fact that one is giving evidence remotely by reason of a medical condition does not make one immune from the court assessing that evidence and arriving at whatever view the court thinks is appropriate on that evidence.
I mean, this wasn't a demeanour-based assessment, was it? One suspects it was an assessment based upon the inherent probability of someone taking Mr. Lambani's phone, pretending to be him, and making incriminatory statements, as they would be for Mr. Smith.
Yes, and that happening without those representing Mr. Lambani ever suggesting any possible motive for why somebody might have for doing that. So, yes, it's also, for what it is worth, as you can see from paragraph 382, it is also based in the court having due regard to the witness statement, which was filed without any sickness being involved, and the change of position in the oral evidence. So that's 382, with the court looking really, in my respectful submission, very carefully at the evidence and the surrounding circumstances, and as my lord has observed, doing a proper job of, well, my lord didn't say proper job, undertaking the task on the face of it the court is supposed to do, which is assess the inherent probabilities of evidence being correct by reference to all the surrounding circumstances. So that's 2 and 2 or 3. There is then talking about conversion of the 959 after the raid. And we can see at 385, you can see at 384, there's reference of how Mr. Edwards got hold of a phone number, and I don't need to focus on that. Then at 385, the position of Mr. Lambani is a difficult one. His approach to disclosure and cooperation with the court process was a straightforward stonewall. Disclose nothing, admit nothing. And again, my lord, I invite the court here to read the word disclose there to relate to both documents and anything else which he may have revealed in his witness statement or indeed oral evidence. Then the court says it was entirely clear from his evidence that some of his witness statement was untrue. However, the question for me is to whether I believe Mr. Lambani was in fact engaged in a conspiracy to convert Mr. Carl's cars. I do not think that he was. It seems to me to be clear that Mr. Lambani was acting throughout as an instrument of Mr. Smith, and that his role was aimed at securing Mr. Smith's position, in particular money he had led to Mr. Edwards. Mr. Lambani's evidence was that he'd never spoken to Mr. Edwards. I do not believe that. So again, a further finding of this particular witness not telling the truth in his witness statement or oral evidence. But that is not itself sufficient for me to conclude that he was Mr. Smith's co-conspirator. Equally, though I accept that Mr. Lambani facilitated the attempted disposal of Mr. Carl's cars, I do not believe that he ever had sufficient possession of the cars to trigger liability and conversion. I also note that he never owed any duty in equity and common law to Mr. Carl as a true owner. There is no doubt that Mr. Lambani has not told the truth in his evidence. However, I think the totality of the evidence within the factual matrix makes clear he is not liable in conspiracy or conversion. Now, that is a judge, in my respectful submission, where it is deeply unfair to characterise his view as he did not like Mr. Lambani.
Might be said there are two conspicuous acts of fairness there, because although I can't find any evidence of these arguments being raised in the written closing of Mr. Lambani, the judge is referring to legal arguments that you don't commit conversion if you're acting in a ministerial capacity on behalf of someone else.
Absolutely.
And
Absolutely.
the need for possession, either directly or vicariously, to be liable in that tort.
You're right, and my lord has in the bundle the closing, such as it was. And you're right; these are just arguments that weren't articulated. I have no idea, and I have no idea whether they're articulated orally. But what I can see and respectfully submit to this court is that this is not the actions of a judge who does not like Mr. Lambani. That is, with the greatest of respect, not fair. This is the act of a judge who has stood back and has deeply assessed the evidence, has taken the view that Mr. Lambani was involved in the chronology of these cars being taken, has lied about it in his witness statement, has lied about it on the stand, but yet applying the correct legal test, which it appears, from what I can see of the case, the judge went and looked at himself, has taken the view he nonetheless, that my client has not satisfied him on the burden of proof on the balance of probabilities. And my lord just described a second ago, said it might be said there's two acts of conspicuous fairness, and I, as one should often do, I completely adopt that. The suggestion that this was a judge who was being careless as to his findings just cannot sensibly be made, given what we have seen here. And the suggestion that this judge somehow went awry because he did not like Mr. Lambani is, I would respectfully say, unfair to the court, both below and here. It's not a proper argument that can be made. That's not what this judge did. So that's the assessment. All of that is the assessment that feeds through into the costs decision. It is the sentence here or a sentence there. It is the court standing back and looking at the chronology as a whole, assessing and finding Mr. Lambani's active participation in the, I'm not going to use the word conversion, the taking and disposal of these vehicles, assessing he was actively involved in the manners which we have seen set out, assessing that he has lied about that in his oral evidence and his written evidence, and assessing that he has failed to disclose documents relevant to that, and assessing that nonetheless my client does not get home on the legal tests for conspiracy and conversion. And it's that background that goes through into the cost assessment, which we see beginning at page 192. Now, pausing there before I look at the cost assessment, I have taken the trouble in the 15 minutes or 20 minutes or so, I'm going to finish this in just a second, taking the trouble to take you through that, because how the appellant puts what the judge did here, as you can see, bears little resemblance to what in fact the judge did do in terms of his findings. And it is really quite important to understand the depth of the findings and their breadth. Depth in the sense of the court looked very carefully at the evidence, and breadth in the sense that the court has found not just one lie or two lies, but a series of mistruths, and not mistruths about ancillary or peripheral matters, but mistruths about this appellant's role in the fraud, the central engine room of the case. And I make all of those points not to throw brickbats at the appellant, but because, as the court knows, and as I'll bring you to the law, that's pretty relevant then to the assessment of the costs. Whether the lies are a simple exaggeration or something peripheral, or whether the poor conduct, which then the court has to assess, is widespread and or significant and or goes to the heart of the actual fraud, or what I should say for any given case, the heart of the actual claim that has to be resolved. So that's why I took you through it. But we get to the assessment. We can see the cost assessment starts at page 191. We can see that Mr. Limbani comes into the picture in terms of the discussion at paragraph 431, where you can see that the court actively had in mind and took into account the open offers of settlement made by my client before the commencement of the trial. As we'll see when we come to the consequentials hearing, that was a point my client returned to in the consequentials hearing. And then over the page, at page 194, we can see that the court says there'll be no order for cost with respect to Ms. Limbani, and then the court sets out the reason for this. And the reason for this, in my respectful submission, is a summary of the various findings which the court has made as we've gone through and which I have now shown this court. And it's clear that, again, the court has adopted a fair and appropriate view of Mr. Limbani's conduct. He has said in terms that Mr. Limbani has escaped examination of his conduct through a policy of evasion and non-disclosure. I have insufficient evidence for me to determine whether or not he was part of the conspiracy, but I am entirely clear that he knew of and disregarded court orders in respect of cars, and that he has not provided the disclosure which he was ordered to provide. I note in this regard that Mr. Carl put to Limbani in the witness box he had given no disclosure. Mr. Limbani testified there's absolutely nothing to disclose whereof communications. I think this was clearly untrue. I have no problem in principle to deny everything defence. Once it's become clear a party is seeking to avoid examination of their actions through a strategy of deliberate non-disclosure, I think that that party, even if successful in deflecting liability, should not have the costs incurred of the action. Now, a couple of points there. Firstly, it's clear the judge had the right test in mind, which is the phrase, even if successful in deflecting liability, shows that the court knew that the normal order before you depart from it is winner gets the costs. It is clear that the court understood that it could and should take into account the conduct of any given defendant when then working out whether to arrive at a different order than what would normally be expected if a defendant is successful in deflecting liability. And the court has explained in terms, in this summary passage, why the court has taken the view that it has.
Do you accept that at this stage, this is a provisional expression?
Yes, I do. And as we'll come to after lunch, I will accept that something went wrong at the consequentials hearing.
Yeah.
I've got some submissions as to why it went wrong, but I accept that something went wrong. And the question for this court will be twofold there, and I'll finish with this. So the court can go to lunch knowing I'm realistic in this appeal about what arguments are and what arguments are not available to me. I think the court's going to have to work out whether, as a result of what went wrong, there has been injustice. And that part of that will be to look at how the court came to get it wrong. But my second point is the obvious one. You now know what the arguments are that would have been put, because, and I'm glad you did, the court has expressly asked for those arguments, has heard those arguments, and this court can take a view now on it. So I hope the court can go in thinking, well, at least he's being a bit realistic about what's going to happen in the second half.
Thank you. So we'll reconvene. It's 2:15. It's all right. 2:15.
Thank you. I apologise for going over.
That's fine.
Court rise in evening.